joined by very good number. So let's get started then. So am I audible? My mic is clear?
Yes, ma'am. Yes, yes,
Okay.
yes.
Okay. So first of all, when as we know that right to privacy, this topic is known by all of you. But you know what we know, it is not important. Understanding right to privacy in its legal context is important. Now, I myself have limitations too while talking about right to privacy. I'll be talking right to privacy in Indian context, and the title of the topic is very vast. So I have divided this topic into various categories. As I learned from you that I'm addressing graduate students, law graduates specifically. So I'll be discussing today meaning of right to privacy, evolution of right to privacy in India, and then I'll be discussing Puttaswamy case and post Puttaswamy case, and I will be talking difference between public space and private space, and also how privacy is protected under the Indian laws. And if time permits, I will touch upon Personal Data Protection Bill 2019, which came up recently in 2019, but it is still pending. It is not decided yet. So after that, I'll conclude the topic. So basically, when we start with the concept, what is privacy? Now, if we look at Constitution, the Constitution of India encompasses right to privacy under Article 21. So, which is a requisite of right to life and personal liberty. We all know that, right? So, the scope of Article 21 is multidimensional under the Indian Constitution. Now, why right to privacy issue is an important topic now? Is it a new concept? No, right to privacy was there earlier too. But there are, many cases on right to privacy, but none of the cases were in favor of considering privacy as a fundamental right. Today we are going to talk about that aspects. Only after the passing of a landmark case, that is K.S. Puttaswamy versus Union of India, in the year 2017, right to privacy is given through recognition. Now, if we look into the definition of right to privacy, more into the depth, then we will see that the definition of right to privacy was given by Judge Thomas Cole in Olmsted versus United States. Now, right to privacy is defined as a right to be let alone. Now, what does it mean? A right to be let alone. That means a citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, education, among other matters. So, any person publishing anything concerning the matters mentioned just now, except with the consent of the person, would be liable in action for damages. This is we understand from the definition. Now, the definition which is given for right to privacy, it defined right as a right to be let alone. So, a citizen has right to safeguard the privacy of his own, including his family, marriage, procreation, motherhood, childbearing, and so many other things which comes under the right to privacy. And if any person publishing anything concerning that matter without the consent, that is very important here. The consent part is very important. So in that case, if any person publish anything, without the consent of that particular person, would be liable in action for damages. Now, in constitutional law, the right of people to make decisions regarding intimate matters also comes under right to privacy. Now, the constitutional right to privacy protects the liberty of people to make certain crucial decisions. Now, what are that crucial decisions? That is regarding their well-being. Now that too without government coercion, intimidation, or interference. So here I'm giving stress on these three words, okay? Coercion, intimidation, or interference. So the constitutional right to privacy protects the liberty of people to make certain crucial decisions regarding their well-being without government coercion, intimidation, or interference. Now, such crucial decisions may concern relating to religious faith, it may concern relating to moral values or political affiliation or relating to marriage, procreation, or death. Okay, so these all comes under right to privacy. Now, the government is not constitutionally allowed to regulate such intensely personal matters. So we are segregating our life into two categories. One is our private life, which we do not want other strangers to come in, and we are segregating our public life. So we are now here, differentiating between public life and private life, personal life. And in constitutional law, the right of people to make personal decisions regarding intimate matters comes under right to privacy. Now, the jurist Salmond also defined the definition of right to privacy. Now, according to him, rights are interests protected by rules of right. Now, that rules may be moral rules, that may be legal rules. So, when interests are worth protecting on moral grounds, irrespective of the existence of a legal system or the operation of law, they are given the name of a natural right, basically, which we call it as natural right. So, accordingly, Roscoe Pound refers to natural law. And he said that as a theory of moral qualities inherent in human beings and the natural rights as deductions demonstrated by reasons for human nature, everything which we call it as basic rights are automatically fundamental rights, and it is called, the rights which is inherited by each and every individual. Now, right to privacy is an element of various legal traditions to restrain government and private actions, that threaten the privacy of individuals. So we are protecting ourselves from the, government or other private actions from the arbitrarily intrusions. Okay, so we do not want the government comes in our life and takes all the secret informations, intimate decisions, or crucial decisions which we take in our life and interfere. That it comes under the infringement of right to privacy. Now, so we can acquire a few distinctive features of right to privacy from these definitions. Like a right to privacy is the right to be alone. Okay, this is one. It is a classic turn on our negative right, where other people have a responsibility to not interfere in your affairs. So it is a kind of a negative right imposed on the other people, and they have a responsibility not to interfere in your affairs. And the second category of understanding of right to privacy is the right to privacy is right in rem. The right exists against the world at large. Okay, and the third category which we understand from the definition is the right to privacy is a part of an individual's inviolate personality. Okay, so now moving forward, how right to privacy became a human right. Okay, now as we are talking about natural right, basic rights, now we have to relate it with human right. Okay, so how right to privacy became a human right. So anything which we relate it with human being is human rights. All we know that. It is our basic rights. Now, fundamental rights are basic rights which are inherited in every human being. And such rights should be endowed with every citizen of the country along with proper remedies. Now, many human rights are fundamental rights or vice versa. Like for an example, right to life, right to education, right to social and political rights, etc. So we have seen that how human rights are fundamental rights. Now the important question is, what are the attributes of right to privacy when it is called as fundamental right? That is important. Now, the attributes we should understand. What are the attributes of right to privacy when it is called as fundamental right? Like privacy can be classified in different manner. Okay. Now, right to sleep is my right to privacy, and I don't want others to disturb me. Okay. So I can call my right to sleep is my right to privacy. I can also say right to forget or right to be forgotten. It is also my right to privacy, and I don't want others to criticize me because I have, right to be forgotten or right to forget. Right to browse internet is my right to privacy, and there are so many other matters which comes under right to privacy, and I don't want other public or the private service providers comes and infringe my right to privacy. So these all are few things which we got to know from the discussion when we talk about how right to privacy become a human right. So right to privacy is not only accepted nationally, but it also accepted internationally and by various conventions. So right to privacy is a fundamental right in the Universal Declaration of Human Rights 1948. According to Article 12 of the Convention, a person's privacy, home, family, marriage, procreation, everything which we call it as intimate affairs, it should not be subjected to any arbitrary intrusion, or the honor and reputation should not be attacked. So law confers on every person the right to be protected from such intrusions or attacks. Now, we have also seen the International Covenant on Civil and Political Rights, 1966. It also talks about right to privacy according to Article 17 of the Convention, to which India is also a party, okay? That states that person's privacy, home, family, or correspondence should not be subjected to any arbitrary intrusions, nor honor and reputation should be. So similar to UDHR. Then the European Convention on Human Rights 1953 also deals with right to privacy. According to Article 8 of the Convention, a person's privacy, home, family, or correspondence should not be subjected to any arbitrary intrusion, nor honor and reputation should be attacked. And also there shall be no interference by a public authority except such as in the provided by or accordance with the law. So within these conventions, what is similar is we are talking here about person's privacy, we're talking here about person's home, we're talking here about family, correspondence, and many other intimate affairs which should not be subjected to any arbitrary intrusion. Okay, and it also includes honor and reputation. Honor, defamation, we know now these cases. So these all also comes under right to privacy, and we do not want government, state, or any public authority except with the permission or given empowers the powers to investigate or record our messages or invade our privacy. We cannot tolerate this type of activities. So therefore we could see the transformation in the legal field, okay, transgression to transition, okay. We could see the transformation as a whole in the legal field, how it is changing with the passage of times. Now the basic thought behind prefacing of such a principle of right to privacy was to protect personal writings, okay, and personal data or personal productions, and its scope extends not only from theft and physical misuse, but against publication in any form. So no one is allowed to publish without the consent of the owner, the person who has created, the real owner. So now let's talk about the machine learning process. A bit about machine learning process to give you more understanding about right to privacy. Now when I talk about machine learning process, by the help of machine, I am communicating with you all today, and you must be recording this session too, which is also comes under right to privacy. Because when I am doing session, I'm not consulted or I have not given my consent, whether you are allowed to record it or not. That comes under right to privacy. and I am using Google Meet, and Google have my identification and location, and we are in that stage now. So now tell me what is wrong in it if Google keep my records. Now what happened to the data, or the data which I share with Google, and how far it is safe? And if it is safe, why do we talk about cybercrime and hacking and all? Why do we need to change our password frequently to protect ourselves from hacking? These all are the matters of informational privacy, which we do not want to share it with strangers. Okay, so these all are privacy. This is the reason why today we are talking about right to privacy, and we are claiming it as fundamental right. Now, the current approaches to privacy and machine learning can be simply described basically in two sections, which are usually which comes under one in case of user control method, and the other talks about data protection. Now, under the user control section, users' rights can be prescribed by understanding what is being collected by whom, for what purpose, and for how long, duration, the time limit, etc. These all comes under the section user control. Now, when we talk about data protection, now data protection section is also combined with encryption of data. Okay, and we are talking here about privacy, and but we do not know what data we are sharing with whom, and who is the third party, again taking it from the service provider and sharing it with the many other service providers, the private service providers. So therefore, the data protection section, encryption of data when it is at rest, and when removing identifiable information to make data which is anonymous, is being fundamentally carried out. So this we need to think and worry about. So privacy preserving learning techniques are usually done using cryptography. You must be knowing the fact that when we talk or send messages in the WhatsApp, it is written that it is end-to-end encrypted. Okay, therefore your data is secured, and you have the right to privacy, or the privacy has maintained by the service provider. But important part is something which we share, or we share our personal data voluntarily. What happens to that data? Sometimes involuntarily also we share, because we do not know. Remember, when we click on I agree button, okay, we actually give our consent to the service providers. So we don't even go through the agreement, but hurriedly when we download any apps, or any, for that matter, any services online, what we do is just to know it, or hurriedly we click on I agree and we move forward without reading the terms and conditions and the agreement, and what it is written there, no one we read it out. So what happened after that? Whatever you give, by clicking one tick or clicking one tab, you are giving permission to the service providers to go through your messages, to go through your files, to go through your pictures, or any intimate or personal or official communications, or relating to the transactions. So that is the reason why we are concerned about online privacy. Now, why is online privacy is concerned? It is important for various reasons, because I don't want to share details of my personal life with strangers whom I do not know. And it is similar to, you also. And it is difficult to be sure what personal information is gathered and by whom information collected by one company might be shared with another company. Okay. And this talks about online privacy. The Justice B.B. Sri Krishna Committee says that it is necessary to create a collective culture that fosters a free and fair digital economy, respecting the informational privacy of individuals and ensuring empowerment, progress, and innovation through digital governance and inclusion. Having said that, it is also very interesting to look at the journey from right to privacy to right to privacy as a fundamental right. Now, before Puttaswamy case, right to privacy was not a fundamental right. The Supreme Court's ruling in Puttaswamy case 2017, after that, it declared privacy as a fundamental right. Now, post judgment, various aspects are given importance, like for an example, bodily privacy, mental privacy, physical privacy, informational privacy, concept of data, data protection, data privacy, online privacy, and many more, etc., which are related to that. Let us see evolution of right to privacy. Okay. Now, if we look at the pronouncement, judicial pronouncement, privacy was not a fundamental right. It was first held by Honorable Supreme Court in the year 1954 in MP Sharma versus Satish Chandra case. Okay. Now, after 9 years later, in Khadak Singh versus State of UP, in the year 1963, again it was rejected, and the concept of right to privacy was, not regarded as fundamental right. Now, majority of the judges in this case denied right to privacy, but minority opinion of Justice Subba Rao was in favor of right to privacy. Now, 12 years later, Supreme Court in the case of Govind versus State of MP, in the year 1975, undertook to, elaborate the concept of right to privacy, and court declared a limited fundamental right to privacy as an emanation from Article 19A and Clause D and Article 21. Now, the right was not absolute, and the reasonable restrictions can be placed by a procedure established by law. So this is how our evolution of right to privacy. Now, after that, gradually right to privacy start to evolve. Okay, and it started protected and preserved by various judicial pronouncements later on. So in 1999, in State versus Maharashtra in State of Maharashtra versus Madhukar Narayan Mardikar, in this case, the Supreme Court protected the right to privacy of a prostitute, and the court held that even a woman of easy virtue is entitled to her privacy, and no one can invade her privacy, as and when they likes. This is one of the important judgment where the right to privacy of a prostitute in that particular case was decided. So in other way, if we do not have right to privacy as a fundamental right, but in spite of that, we have been seeing this type of judgments coming up to protect the person's right to privacy. Now, in the case of Surjit Singh versus Kanwaljit Kaur case, okay, the Punjab and Haryana High Court held in that particular case by allowing medical examination of a woman for her virginity test and said that it amounts to, violation of her right to privacy and personal liberty, which enshrined under Article 21, right to privacy and personal liberty. So this is how we have seen in this case also how it is protected. Now, in Banarasi Das versus Tiku Dutt, in this case also in the year 2005, Honorable Supreme Court stated that nobody can be compelled without his or her consent to submit to DNA test. So few cases we learned that how privacy was protected by the law. Now let us know first K.S. Puttaswamy case, and then I'll go post Puttaswamy case. Okay. Now in Puttaswamy case, it is also known as Aadhaar case. Okay. And the unique identity scheme was discussed along with right to privacy in this case. Now, Justice K.S. Puttaswamy and another versus Union of India and others challenged the Aadhaar scheme on multiple grounds. This case was filed in the year 2012. Judgment was passed in the year 2017. Now, Aadhaar is a unique 12-digit identity number which is issued to all the Indian residents. And, it is the world's largest biometric ID system where over 1 billion individuals' data having been collected by the Unique Identification Authority of India, UIADI. Now, the Aadhaar number can be used for governmental benefits. It can be used for collecting taxes. It can be used for monitoring financial transactions and many more. Okay, which we do not even know now how that can infringe our right to privacy. However, the court in this case, Puttaswamy case, did not hold that privacy is absolute. Okay, the decision does not overturn other or any other governmental schemes, but it lays out the tests that will be used to adjudicate whether the government scheme might infringe the multifaceted right to privacy. So what is the need of Aadhaar in India? If we ask these questions to ourselves, what is the need of Aadhaar in India? Is it required biometric or identification to receive some of the benefits like subsidies provided by the government? Why do we need to give biometric to receive subsidies? This is also another type of questions which comes to our mind when we talk about Aadhaar issue. We are living in a welfare state, right? So whatever welfare schemes are coming up, that should be given to the people without, thinking that whether it is, biometric given or whether they have Aadhaar or not. Now, few people have opinion that, it can be a kind of surveillance by the authority because Aadhaar is linked with SIM card, Aadhaar is linked with PAN card, Aadhaar is linked with, bank account number. So if we travel by air also, we are asked to provide Aadhaar card as a identity card. So the state can surveillance whereabouts and other things of our, myself from that scheme, or, like what is my political affiliation that can be known from the Aadhaar, card, or sexual orientation and many more things which can be known from that, scheme. So look at the status we stand, or look at the situation where we stand today in view of right to privacy. Why don't center look for other means to provide benefit or subsidy to its people without taking or invasion of right to privacy? Because invasion of right to privacy is which we talk about today. But when we look at the schemes and other subsidies and other benefits given to the people, we again, come to that dilemma, what should be done? And we have no answer for that. Because taking biometric and individuals, it is again, kind of an invasion of right to privacy. So few of the people have the opinion also that the level of protection given to the biometrics data is insufficient. So the data which we have provided to the authority, if someday if the data is leaked or somebody has taken my biometric and committed crime, I have clueless for that matter, and therefore maybe the responsibility may come upon me. So that is, therefore it amounts to invasion of right to privacy, and that's we are discussing today. Now, two things pops up in our mind out of this discussion. One is what is identification, and the second is what is authentication. Okay, so biometrics are collected from an individual for the purpose of other and other government subsidies, as other target to provide benefit subsidy to the people below poverty line, like for an example food grains, LPG, ration, MNREGA benefits. These all are some of the benefits which are given. So as a rightful person, whether the rightful person is getting that benefit or not, that Aadhaar is taking care of. Now, because it also authenticates the person existence, whose biometric is there in the system and who is getting the benefit. So whether he or she is getting rightful benefits or not, that is the monitoring factor which Aadhaar is giving, putting forward their opinion. Now, if we look at that angle, Aadhaar is again looks like a valid law. Okay, but the problem is, why taking biometrics to provide benefits or subsidies? because collecting biometric is again invasion of right to privacy. So there we need balance. And the balancing part, the Supreme Court said in Puttaswamy case that right to privacy can be invaded. Okay, we are calling it as right to privacy as a fundamental right in the beginning, and now the Supreme Court also said in Puttaswamy case that right to privacy can be invaded but subjected to legitimate state interest or purpose limitations, and the law should pass the test of proportionality. These three things are there in the judgment. Okay, so like other fundamental rights, right to privacy is also not free from restrictions. Okay, so there comes now the reality. So after passing the judgment, Justice B.B. Sri Krishna Committee framed to prepare a draft law, okay, bill on right to privacy. Now, it is because to inquire into what steps government or taken by the government to protect citizens from unwarranted intrusions, and see the steps the government has taken to address and the potential risk to privacy. Now, especially privacy and technology development. If we talk about privacy and technology development during COVID-19 pandemic, it is also very interesting, especially with machine learning system and the serious challenge which people are facing today. Now, we are in an information age, right? So with the growth and development of technology, more information is now easily available. The information explosions has multiple advantages. By clicking one, enter, we are getting multiple of options relating to our choices, our preferences, what we look for. But it has also, some disadvantages. So the access to information which an individual may not want to give now needs the protection of privacy. Now, some apps are infringement of right to privacy. We all know that, like Arigdo Setu app, Cam Scanner, Fitness app. There are so many other apps, okay, which are coming up. Even the Zoom app, which was in the last year in the COVID pandemic, suddenly zoomed up, and lots of controversy arose regarding the right to privacy. So this is how the apps are infringing the right to privacy of individuals. So what happened after Puttaswamy case? Now it is post Puttaswamy, what the effect or impact of the judgment on other issues. Now the case on Aadhaar, it is still pending. It is just said that it is the steps which is given to the government to look at whether they are infringing by allowing the schemes right to privacy or not. Okay, so the case on Aadhaar is still not decided, and hence it may take some time. But the contours of what the government may need to do to satisfy constitutional scrutiny is provided in this decision. So the government will need to show now how it is planning to protect individuals' privacy from unwarranted invasion of their privacy and protect information that is collected. So all the biometrics and whatever, the specimens which we have given to the authority, that needs to be protected by the government. Secondly, the judgment, Puttaswamy judgment has have impact on LGBT rights also. And LGBT rights have a boost from the judgment because a number of the justices quite clearly stated that their recognition of a constitutional right to privacy carries with its the implication that the Section 377 ruling is, and it is on a very shaky footing. So therefore, this would be a boost for LGBT rights, recognizing a right to privacy that applies to LGBT, and it is an important step. Okay. And thirdly, after the Puttaswamy case, if we look at the cases of the impact, the beef ban cases, okay? So if the right is interpreted to include what food people can eat or their profession in some cases, like butchers. So in that case, it is none of others' business to look at what I am eating. So therefore, it comes under right to privacy. So the beef ban cases may have impact on that particular ground. Moving forward. There are interesting issues about what the right to privacy means for e-commerce, attempts to battle corruption, and black money, surveillance activities, and so forth. Okay, so therefore when we talk about these issues, it is very interesting to look at. Now, in several aspects, right to privacy may come in conflict with the investigation of police too, because various tests such as narcoanalysis, polygraph, lie detector test, and brain mapping tests make unwarranted intervention into the right to privacy of a person. So, in case of Selvi versus State of Karnataka, the Supreme Court acknowledged the distinctions between physical privacy and mental privacy. Now, the physical privacy and mental privacy are separated, and it was stated that in this case, the clause right to privacy clubbed together with article 20 clause 3 of the constitution, which also talks about self incrimination, some information which is stored in my brain, in my mind, and which I may not wanted to willingly, okay, disclose it to other persons. So in that case, if by incorporating drugs like narcoanalysis, if somebody try to know the information, then in that case it also comes under the infringement of right to privacy. Now, although the Puttaswamy judgment talks for privacy as a fundamental right, India, for real, we does not have a strict law or any specific law or provisions for the protections of individuals' data. So, whatever protection is given to the data, it flows from IT Act and the other IT rules. So the Personal Protection Bill, PDP, which is known as PDP 2019, that seeks to provide for the protection of personal data of individuals, and it is still pending and a debated topic in the parliament. Now, what is data? We are talking in various occasions the data protection, data privacy, online privacy, and data relating to data. Now, what is data? Now, data is information, or it is a knowledge, or it is a fact. Now, in the digital age, individuals are constantly generating valuable data, okay, which can be used by state and non-state actors to track individuals' moves or choices and preferences. I'll give you a small example on this, note that like when many youngsters, like the students, the graduate students, and the students, because I'm addressing the students, so I will relate it with you, and I'll give you one example. Like for example, nowadays we watch movie online, right? Netflix and Hotstars. We watch, we like to watch movies on that particular platform. Now, look at the situations when you watch one movie, one thriller movie for that example, or maybe one movie relating to adventure. Okay. Now, look at how Hotstar or Netflix customize your likings. Okay. That means they are tracking your likings, your professions, your moves, how and what type of movie you like to watch, and then they share, okay, that customization, that things with the other public providers. So look at the Netflix, how Netflix is customizing your likings, and look at the Hotstar, how Hotstar is customizing your likings depending on what you have watched earlier, and on similar ground they customize it, similar movies, and gives you the preferences. And that is called, they are observing your movements. That is the tracking by either state or non-state actors, as I have already said. This is how it is, carried out. Now the data is generated not just by active sharing. Okay. When I say that I am sharing data, sometimes I share data, okay, by active sharing, but sometimes I may not. It can be passively sharing data. How? By clicking on the World Wide Web, www. The moment I click on, either they ask me to sign in, either they ask me to agree, either they pop up by advertisements and say that, this is how the similar articles are coming up. So if you go for looking for an article also, the similar, things are, shown by the web providers. And this is what we talk about, the passively data sharing. Okay, so like for example, another example I would like to cite here, like how Uber and Ola, these all are the apps we keep it in our mobile phones. Okay. Now, Uber knows our whereabouts and the places we frequent. Okay, when we use Uber and Ola services. Facebook at least knows who we are friends with. Okay, Alibaba, Mintra, Amazon, they knows our shopping habits, how frequently we do online shoppings. Now, social network providers, search engines, email service providers, messaging applications are all further examples of non-state actors that have extensively knowledge of our movements, okay, financial transactions, conversations, both professional and private, health, mental state, interest, our travel, locations, fares, and shopping habits. These all are known by them. Now, there is a need for protection of such information from the state. Now, let's talk about privacy and Arigyo Setu app. Okay. Now, Arigyo Setu app is a new application launched by the government of India to make aware the citizens so that they can protect themselves from getting away with a deadly coronavirus. Or the deadly pandemic of coronavirus against which the whole world is fighting in the present time. Now, the app promises to provide information regarding the COVID-19 positive patients so that the other people, they could save themselves from getting infected or in contact with the infected person. Now, the app is used with the support of Bluetooth services that are available in the Bluetooth in the mobile phones. Okay. Now, when the Bluetooth services of the mobile is enabled, then a victim is highly prone towards getting affected by the cybercrime called blue bugging. Okay. Now, what is blue bugging? Blue bugging is a technique, and that technique allows skilled hackers to access mobile commands on Bluetooth enabled devices that are in discoverable mode. Okay, so look at the vulnerability. The vulnerability allows our cyber criminals to intercept and monitor the data exchanged from a device in proximity. So these low falls affect devices from Qualcomm, Broadcom, even the Apple. Many Android handsets are also at risk. So the cyber security in India is not considered as strong as it exists around the world. Okay, so we have been seeing many cases, many instances, the cyber crime, the hacking, Facebook fake profiles created. These all are few things which we face in our daily lives. So, despite various laws have been passed by the government of India in order to protect people from cyber crimes, the impact of cybercrime in India has not been reduced, as because of the lack of jurisdiction for cybercrime cases in India. Okay, so this is how the Arigyo Setu app is considered one of the major issues towards infringement of the privacy right. And this is the privacy rights of the people that can be easily attacked due to enabling of Bluetooth services in the device. So there are various other aspects of infringement of right to privacy as well. It is not only the Arigyo Setu app who is infringing right to privacy. There are lots of other things. Okay. So for example, phone tapping. If I tell you that phone tapping and right to privacy. Now, I'd like to mention one case law here in People's Union for Civil Liberties versus Union of India. In this case, Honorable Court laid down certain procedural safeguard, to be observed before resorting to telephone tapping under Section 5, Clause 2 of Indian Telegraph Act. Okay, so except the Indian Telegraph Act 1885 empowers state are not allowed to intercept messages, telephone tapping, and if they do, it would be violation of right to privacy. So the telephone conversation is an important conversation in the privacy of one's home or maybe office, and without interference can certainly be claimed as right to privacy. And therefore, nobody is allowed to tap without the power given by the Indian Telegraph Act, the authority, or maybe the person concerned. So even in case of gender, or in case of in the context of sexual orientation or sexual identity, and the right to privacy also we have seen in LGBTQ cases. Now women's right to make reproductive choices also comes under right to privacy, because if we look at the judicial pronouncements in Suchitra Srivastava versus Chandigarh administration, a three-judge bench of the Supreme Court, headed by Honorable Chief Justice, stated that the scope of women's right to make reproductive choices in view of right to privacy, it needs to be secured as an important facet of right to personal liberty. And court also said that it was important to recognize that reproductive rights or reproductive choices, because a women could be, can exercise procreation as well as abstain from procreation. So it is her right to choose. Okay. So stating that women's right to privacy, dignity, bodily integrity was of crucial consideration, and it was requested by court to give respect in this regard. Now, if we look at another present situations, the youngsters, they are following the trend, okay, like live-in relationship. Live-in relationship also comes under the purview of right to privacy. Now, India is a free, democratic, and secular country, and therefore, any person who has attained majority has the right to live freely with anyone. Okay, so it is decided in the case of Jyoti versus state of UP. Now, in this case, Allahabad High Court stated that a person, he or she, who attained the age of majority, 18 years of age, and which is known as major according to Section 3 of Indian Majority Act, and he is eligible and deemed and understands the welfares of his well-beings, and hence she can go wherever she likes and live with anybody. Even she could not be restrained from doing so by their parents. And this is what the judgment talks about: right to privacy, live-in relationship and privacy. And there are many other, even the health sector, if we talk about health rights and right to privacy, hospitals keep confidential secrecy, okay, they maintain secrecy of their patients, the doctor. So now the question is, if the doctor disclose patients, about patients' confidentiality, the secrecy, whether the doctor will be held liable or not. We have seen a famous case law here also in this health and right to privacy, Mr. X versus Hospital Z. Okay. Now the question before the Supreme Court was whether the disclosure by the doctor about his patient who was to get married had tested HIV positive would be violative of the right to privacy or not. This is an very important component of right to life emphasized under Article 21. Now, Supreme Court rolled out that and said that right to privacy was not absolute right and might be lawfully restricted for the prevention of crime, disorder, or protection of health, or morals, or protection of rights and freedom of others. So we have seen that, like other fundamental rights, in case of it raises questions about the interest of larger people, then in that case it can be evaded, as we know that right to privacy is not absolute. So this is how we have seen judicial pronouncements on various grounds, how they have protected right to privacy. Now let us look into legislative part, how it is the privacy is protected under the Indian laws. Now, legislative provisions related to privacy. As I have already mentioned in my various discussions, the case discussions, I say that the Indian Telegraph Act, it is one of the legislation which protects, ourselves from tapping, phone tapping, okay, or intercept. This is the law which protects our privacy. Then family law also protects our privacy, like in case of family matters, the family disputes. Okay, um, it is suggested that sometime hearing in camera proceedings in certain marriage and divorce cases can be allowed. So this protects the privacy of the couple or the family or home. Okay, in that the confidentiality of the proceedings is sometimes desirable. So therefore the court allows the right to privacy for of the couples. Then Indian Evidence Act also protects right to privacy. There are provisions in the Evidence Act, section 24, section 25, talks about the privacy. This talks about how the law protects the privacy interest of accused person in view of the presumptions of innocence, which appears to have been caused by any inducement, a threat, or promise, which is not even admissible in as an evidence. So this is how it is protected that way. Now, criminal law also protects right to privacy. There are provisions in the Criminal Procedure Code, Section 51, Clause 2, Section 53, Clause 2. It talks about the protection given to the people. Like, for example, the Section 51, Clause 2 talks about the states that can necessarily take precautions when the female to be searched, and the search shall be made by another female officer, not by the male officer, and which is strictly regarded to decency. And then Section 53, Clause 2 talks about the person of a female when it's taken for medical examination under this section. This is again, the examination shall be made only by the women, the female registered medical practitioner. So these are the laws which we have seen under the criminal law, how it protects the privacy of women. Now, Information and Technology Act, as we all know, for that matter, Information Technology Act 2000, or it is 2008, we have seen that broadly it talks about data protection. Okay, so this act makes a provision to protect data, information secured from the electronic record, book, registered correspondence, etc. So from disclosure to any other person makes it a punishable offense under this act. And we have now recently another rules. Information technology has passed the new guidelines, in the new information technology intermediary guidelines and digital media ethics code to 2021. This rules talks about now the WhatsApp controversy. Okay, that talks about that WhatsApp controversy. That rules talks about that. So look at these situations when we talk about that aspects. So what is important is prioritizing the privacy. It is very important. Now, with shifting towards digitization in education, entertainment, banking sector, and almost everything, it is now time that people understand that privacy is very crucial and shall not be compromised at any cost. The way forward is more privacy centered apps we are looking forward. Okay, so sometimes you may say that what if the app is infringing and we came to know, and why don't we delete it? Why to keep it in the mobile phones or devices? And installing the app is not a solution. I'm telling you, even deleting app does not do it all. The data that already exists stays with the company and will still be shared among the other apps. Like for an example, Paytm, Bheem, UPI, which we all do. Okay, in certain situations we have to download and we have to use that. But what that data we are sharing, our transactions number, our ATM card number, with the secret code, everything. So therefore, this infringes our right to privacy. Now, India currently does not have any express legislation governing the data privacy protection. So while the transition to a digital economy is underway, the current primary law which regulates data privacy is the information technology. Okay, reasonable security practices and procedures and sensitive data or information rules 2011. This is the law which governs our data, online privacy, whatever data we share with the service providers. Now in December 2019, the government introduced Data Protection Bill 2019. Now, which would create the first cross-sectoral legal framework for data protection in India. Now, the bill is largely modeled on the GDPR and aims to protect the information privacy of individuals by creating a preventive framework that regulates how business sector collect and the use personal data. Okay, so the objective of this bill is to ensure growth of the digital economy while keeping personal data of the citizens, and also how to secure and protect that data. Now remember, we often commit mistake while downloading apps by clicking I agree without even reading it. Now what happened when we disclose in social media about our gender, our caste, our religion, marital status, places we visited, and so many other things, including your date of birth? Okay, when you disclose all the information asked by the private apps and social media websites, you are very close to defining yourself as a person. Okay, and it is also precise and accurate descriptions of what a group of companies you had never heard of, personal data trackers, have learned about you. So we already know about the fact that our daily records being collected by service providers such as Google Maps, search engine, Facebook, contactless credit card transactions. These all are few things which we know that they are tracking every day our movements. But sometimes we combine it with public information like voter cards, okay, a PAN card number or saving account number linked with mobile number. So in Arigo Setu app, for that example, we had to get to get vaccination, we have to give the PAN card number or Aadhaar card number or the other number which you show it as or take it as identity of yourself. And this reveals a lot about you, whether you are optimistic, whether you are political, whether you are ambitious or risk taker. Even your smartphone can also reveal your exact location. Where is the protection law? Yesterday I was going through my mobile, I was cleaning my space, okay, in my mobile, and I saw that in the settings there are certain things which are already in default, which are already on. Okay, that means I am sharing my information with Google. Google is reading my messages. Google is reading my personal profiles, files, whatever I am downloading, whatever communication I'm doing it with my personal, family, friends, and other people in the capacity. So this is how it is going on. So where is the protection law? And that means you are not safe even at your own home, because some anonymous group is tracking every day your behavior, especially online shopping with zip code number and the contact number, which has a high risk of being followed by the tracker, and it is infringement of right to privacy. So we need privacy and security. We are concerned about information mishandling. We are also concerned about snooping. We are also concerned about location tracking. So therefore, we need both privacy and security. So security is about safeguarding of data shared online, and privacy is about safeguarding of users' identity. So security refers to protection against unauthorized access of data. So that is the reason why we put security control in place to limit who can access the information of ours, right? So this is how I conclude my topic. Although efforts have been made to define right to privacy, but there is no concrete definition of right to privacy. In India, legislation hence the first step which should take is to define the right to privacy in order to protect the right of individual. And in current scenario, it becomes very important to give a definition which covers all the aspects of right to privacy. So right to privacy is a fundamental right, but it is a right which protects the inner sphere of the individual, but from interference from both the state and non-state actors, and allows the individuals to make autonomous decision, okay, life choices. And it is highly observed that the technology has made it possible to enter a citizen's house without knocking at his or her door. And this is equally possible both by state and non-state actors. and it is now an individual's choice as to whether who enters his house and how he lives and in what relationships. So the privacy of the home must protect the family, marriage, procreation, sexual orientation, which are which are all important aspects of dignity. And if the individual permits someone to enter the house, it does not mean that others can also enter the house. Okay. So the only check and balance is that it should not harm the other individuals or affects others' rights. Okay. So our rights is at the cost of others' rights. So this is how we have to balance. That's all. So thank you.
Thank you, ma'am.
Thank you
We
very
have
much.
some.
Great.
Yes.
Uh, Duhita, are you there? What a deliberation, ma'am. Really, very. You are. We could understand from your speech that how concerned you are with regard to privacy and how concerned about the data protection you are. We could understand it from your deliberation. And
Thank you.
also,
Thank you
yeah.
so much. So, do I have any question
Yes,
answer
ma'am, yes.
session?
There are some questions. So I was just waiting if Duhita is online. If she's
Okay.
online, but I think some network issues is there.
Yeah, even I'm getting.
Yeah. So, ma'am, there are some questions as to the out of rage, the girlfriends and boyfriends after breakup, they share the personal uh, pictures or videos out of rage. Out of rage, when the girlfriend or a boyfriend discloses the personal pictures or videos, uh, just to harm the reputation of the other person. So, does that also amount to privacy, and what remedies are available?
Yes, yes, this is a very relevant question indeed, because when I talk about that, live-in relationship, I was also thinking of talking, but as you know that the limited time framework of today's
Yes,
this session, so I had to limit my lecture. Actually, it is very important when people started living, staying in living relationship. Sometimes even the girlfriend and boyfriend, that relationship. Okay, so many of the couples, they face this type of situations when it harms the reputation and honor. And I have already mentioned the law. Okay, even in the Universal Declaration of Declaration of Human Rights, then the international level, and in the national level we have IT Act, even IT rules, which talks about the maintaining about the privacy. So therefore, if somebody do such type of activities, going and breaching the privacy law, then in that case they will be again punished under the IT Act. This is what I know. And now we have seen that as a whole, as a specific, like for giving obscene pictures of a couple, or some other things, that will come under obscenity if it is obscene in nature. Okay, so again, it is depending on case to case circumstances, what type of pictures that couple is distributing, and what is in nature, whether that picture is actually comes under the definition of obscenity or not. So many things are there. So looking at all, either if it is circulated in online, the IT Act will take care of it. And it is also a personal, if you go to the police station, you can complain as an individual to get it back, your right to life and personal liberty and the dignity, especially if it is a woman, the dignity comes into the picture. So that you can go and claim for. And therefore you can also go and claim your right by saying that it is a kind of damaging of my honor and reputation. So there are lots of other ingredients ingredients which I have already mentioned in my lecture. So that way, now we have to look at the situation. Now, what are the pictures, how it is provided, under what capacity, whether it is shared during the time of having relationship or not, or it is done by done by the couple or one of the party to injure the other one. So we need to look at that aspects also. Okay.
Yes, ma'am. So I hope the person Deepam is clear that there are many parameters to check, this particular matter. So there is another person. He's a student. He has shared his experience in the recent time that had taken place in his village.
Mhm.
So I don't know why this particular question was asked by the village women, as to the women have asked the lady who delivered a girl child. She was asked whether she had any kind of sexual relationship with anybody other than her husband, and because she was afraid that something could happen to her life, that is why she had also disclosed that she had a physical relationship with other person other than her husband. So is it amounting to right to privacy?
See, as I said already, even a women of easy virtue have a dignity to live a life like the other human being. So when I talk about dignity here, asking a woman whether she is having a physical relationship with other person or not is infringing of right to privacy actually,
Yes.
because for every individual has their own life choices, and therefore no one can compel and or infringe the right to privacy, okay, for that matter. So it is, even I say it, the legislations which talks about when a person is adult, and even the parents cannot stop the adult person to go to whom he is living, how he is living, with whom he is living. Even section 377, the gay rights now has an impact after Puttaswamy case. So therefore it is important to look at that aspects. But as you all know, we have to wait a little longer for the PDP bill to come out, so that it will be clearer. All your questions will, questions answer will be given after the PDP bill, if it comes as an act.
Yes,
That we have to wait for.
indeed. So, ma'am, Duhita, are you there? I don't know
Yes,
what's
yes.
the trouble.
Uh,
Okay.
I,
And Suresh
dear
is also
participants,
there,
if you
ma'am.
have if you have any queries, then you can directly interact with ma'am also.
Any participants who would want to
No more
interact with
queries.
ma'am can do so.
I think no more queries is there. We are going to conclude today's session. Before concluding, thank you, Rupali ma'am, for enlightening us and also sharing your valuable thoughts and experience relating to the right to privacy and its evolution and also its impact in present context. Today we had the opportunity to hear your thoughts, and this is definitely encouraging us in our future events. Thanks. So thank you, ma'am. Thank you so much for joining us. So now I would like to request our principal, Madam Ms. Prita Verma, kindly to deliver the vote of thanks for today's session.
Thank you. Thank you, Duhita. So it gives me immense pleasure to offer my vote of thanks to Rupali Debbarma ma'am. And I must say that your deliberation was very uh, nice, and you have gave an insight informations regarding the topic, and I believe that you have truly justified the topic, and uh, we could also understand, at least I could understand, that how emotional you are with regard to the privacy issues of every individual, and how, and you wanted to make sure through your deliberation that whenever we download, or whenever we share any such information online, for any kind of purpose or in any other platform, how careful we should be when we are doing so, how careful we should be, uh, we should look after the matters of privacy. We could understand that from your deliberation, and you have precisely uh, given the historical development and the judicial developments by citing the various case laws, be it Kharak Singh case, or be it MP Sharma case, or be it Puttaswamy case. And I also truly believe that, as I also have read the Puttaswamy case at one point of time, wherein I could see that Justice Chandrachud have stated that right to privacy has both positive and negative aspects, as in the state is responsible to protect the data of the citizens. At the same time, the state does not also have the right to interfere into anybody's personal life. So and the data encryption that you have spoken about is something very important, even I believe. And thank you so much, ma'am. And the participants have given their opinion, as in they want to have some similar sessions with you in other platforms. So I would like to tell the participants and students also that we will again try to have ma'am with us in some other platform. Then I think we will have the uh, again we'll get the chance to hear from Debbarma ma'am. And it's my heartful gratitude to you, ma'am. And I offer my vote of thanks to the IQAC team of Kokrajhar Law College for putting online lecture series in order to continue the academic activities, and also to keep the morale high of the students. And also I thank the participants and students for patient hearing. Uh, thank you one and all, and thank you Duhita for coordinating and bringing ma'am to us. So we thank you also. And ma'am, Suresh is here. If you would like to interact, Suresh, are you there? Ma'am wants to talk.
Okay, ma'am.
Suresh,
Okay.
how are you?
Madam,
So you are became a
fine,
teacher.
yes, ma'am. Now at present,
Okay, so what subject?
I'm
What
continuing.
subject? What subject do you teach?
Madam, I'm teaching now evidence, criminal
Okay,
law,
very
ma'am.
good. Okay,
I, I had done the specialization in
yes,
criminal law,
I remember you.
evidence IPC. Hmm. Okay, ma'am.
Yeah. So good to see.
So
Good
much
to
happy to
see
see you,
you
ma'am. After long
coming
gap.
and joining
Hmm.
academics. Suresh, good to see you.
Okay,
You
ma'am.
have joined academics. I have never thought of. You are such a shy guy in the class and never used to ask me questions. And now you are. I mean, like it is something which uh, I learned that you came and joined Kokrajhar Law College when I saw my invitation later. So yeah, it is good.
Yes, he is doing
Thank
good,
you,
ma'am.
ma'am.
He has cleared net also
Yeah, yeah,
already.
yeah.
Yeah, you.
Okay.
He's doing very good. He's trying
So
to
please be
improve
focused, and
personality
yeah, we
also.
need lots of students. Those who are listening, lots of students, please come and join academics, because what the line which we are in, we can impart lots of knowledges to the society, and this is what is important now in today's era. Because see, the lockdown which has given us opportunity to go online, which we never thought of, even never imagined in our dream, that we will be one day conducting seminars and webinars